Okay, so I'm doing the trademark webinar again because due to operator error, it was not recorded 2 weeks ago. So this is Trademarks 101, and I'm going to go right to the screen share so that I can show you the PowerPoint. Let me just pull that up because there's lots of fabulous information on the PowerPoint for you all that I put together. So here's the screen share. And let's make it full size. Okay, great. So this is Trademarks 101. And we're talking about how trademarks have an impact on business and branding. I'm a business attorney, and as you know, I represent a lot of concierge medical practices and med spas and many other types of businesses, local in California, founder-owned and operated businesses. And branding, trademarks, picking a business name, naming a product or service are all an extremely integral part of my practice. So, of course, as an attorney, I have to give you a disclaimer stating that nothing in this presentation is to be considered specific legal advice. The information provided is for entertainment, maybe, and definitely to provide general information. Watching, listening to, or participating in this presentation does not create an attorney-client relationship or the duty of confidentiality between the presenter and any audience member or participant. Any questions you ask or post in the chat box or that you ask orally are not confidential, and you should consult with an attorney for specific legal advice on this or any other legal matter. So now I have complied with my ethical duty, and we'll move on to the meat of the presentation. So what is a trademark? A trademark can be a name, which is known as a word mark, or some kind of artwork mark, or which is also known as a design mark that represents a product or service that is provided to the public in commerce. And the examples I'm giving are two really well-known brands, Nike or Yelp. And I use these two because Nike represents a product and Yelp represents a service. So the word mark would be the words Nike or the word Yelp. And the design mark is the Nike swoosh that we are all, the entire globe of civilized society is familiar with that. And certainly in the US, we're familiar with the Yelp logo there. So those are the design marks that are, and these are definitely filed. So just to get this out of the way, because these questions arise, I just want to go quickly over what the difference is between a copyright, a trademark, and a patent. I see people are coming in. Hi, Lauren. Do me a favor and just mute yourself, please. As you know, I did this 2 weeks ago and I forgot to record it, so I'm recording now. I'm just going over the difference between a trademark, a copyright, and a patent. So copyright protects created works, such as oh, look, I have a typo there. I didn't even notice that before. Choreography, written works like literature, poetry, teaching material. And I mentioned teaching material because a lot of my clients provide services and have online courses or on-ground courses. Any information that you provide to the public via your website or books or other informational modalities can be copyrighted. Music, the score and the lyrics can be copyrighted. Art, painting, drawing, etc. Sculpture, website content, coding can also be copyrighted. Sometimes we don't necessarily recommend this because sometimes you want to keep your coding secret, because once you've got it copyrighted, it is available to the public and people can deconstruct it, but it can be copyrighted. Website content, as I mentioned earlier, clothing design and textile design. I have a client who does clothing and textile design, and one of her really beautiful copyrighted textile designs is being infringed on right now. So that brings that to my mind. A patent is an invention of a product or a process. It must be useful, it must be novel, meaning new, not in existence anywhere else, and it must be non-obvious. In other words, kind of unique or innovative. I don't do patents. Most patent attorneys are engineers, I know very little about patents, but I just mention it because people are interested in the difference between a trademark, a patent, and a copyright. So back to trademarks. A trademark represents a product or service. This is the name or the design under which the product or service is sold. So it can't be just the name of a company that doesn't necessarily provide, or that name isn't necessarily used in commerce to represent that product or service. I had a client come to me and he had a company name that he was emotionally attached to, and he had some kind of little logo and he wanted to trademark it, but it was not presented to the public in commerce at all. So, and it didn't represent a product or service, so it couldn't be trademarked. There are limitations on what can be registered as a trademark. A trademark cannot be decorative, it cannot be descriptive, it cannot be geographic, and it can also not be the personal name of the owner of that mark. There is a cause of action for use of name and likeness, which we'll get into later. So these are the three main challenges that I find with clients who are wanting to get trademarks registered. And this is, I'll show you an example here. So a lot of clients want to produce, specifically t-shirts and hats and things like that. So here is a shirt, and this shirt is provided by Joe Dispenza, who's an amazing meditation teacher. And here's the front of the shirt, and it has the little brain over the little nuclear symbol there, and the logo on the back is mind over matter. Well, mind and then the line matter. These words and this picture on the t-shirt are decorative. They do not brand or label this product, this t-shirt that's being sold. Now, but what they've done is they've also put the little brain design in the labeling portion of the shirt. So because of the location of this brain right here, this design mark can be registered as a trademark. So I work with a lot of clients in figuring out labeling or packaging for their product or service when they have a decorative mark, but they want to file it as a trademark to represent that product. So that's how we do it. Is it has to be in the label on the packaging or on the website that presents the product or service. So that's the decorative issue. The descriptive issue. So here's a little jar of hand cream, and it's by Essie. It says Essie Ejuvenate, and underneath it says intensive recovery hand cream. So those words, intensive recovery hand cream, are descriptive. That describes exactly what's in this jar. Those words are not registrable as a trademark. This word Essie, and if anyone who's in the beauty business, particularly hand care, knows this name Essie. It's a really iconic nail care brand. And this Ejuvenate is the name of the product. That's the name that they decided to give this product. These are what we call fanciful terms. The word Essie in and of itself, if we don't know about this iconic hand care brand, we don't know what that means. It has no meaning to us. Just like the two examples I gave in the beginning, Nike and Yelp, those words mean something completely different than the product or service that they represent. The word Nike is the name of a Greek god, the Greek god of speed or something. But when we, in this entire civilized world, hear that name Nike, our minds immediately go to that brand of shoes and sportswear. And I think they make balls and other things too, all kinds of sporting goods. When we, especially in the US, hear the word Yelp, we don't think of, the definitive dictionary definition of that word Yelp, which is a little cry. We think of the review site that reviews products and services. So those are fanciful words. They don't describe the product or service. So because they don't describe the product or service and they're not decorative, they can be registered as trademarks. A mark can also not be geographic. I had a case with a client who has a service in North County, San Diego, and that service, the name of the company is this service of, let's just say Carlsbad. It's not Carlsbad, it's another city up there. But because of the geographic nature and the descriptive nature, so let's just say it's Carlsbad landscaping. That is a geographic and descriptive name. And because it's geographic and descriptive, it cannot be registered unless that name has acquired a secondary meaning. And that was our argument in this particular case. Just like Nike and Yelp, those names have a secondary meaning to us in the general public. Like I said, when we hear the word Nike, we immediately think of that iconic sportswear and sporting goods brand. So this particular company, we'll just say Carlsbad Landscaping, I think that's what I said, because the company had been in business for so long, the consuming public in that area for that service automatically associated that person's company and the quality that he provided with that name. So our argument was that it had acquired a secondary meaning. I have made these arguments to the California Secretary of State and the USPTO regarding geographic and personal names and descriptiveness in regard to that particular mark having acquired a secondary meaning, and I've been successful with that. It has to be in business for a long time, and there's all kinds of evidence you have to show. But at any rate, you know, the answer to every legal question is it depends. So these are some of the caveats to a mark cannot be decorative, it cannot be descriptive, it cannot be geographic. So now you've got a mark. The big question is, should you register? What is the reason for registering? Well, before a name is registered, and I just went through this analysis with the client who had picked a brand name for their company, their service that they're offering, and hadn't consulted with anybody about the use of that brand and said, we want to trademark it. Well, I did even just the quickest Google search and found 2 other companies in California that were using that name, and my client would be infringing on these senior users because I'm going to go back to that other slide, because as soon as a name or mark is used in commerce under the common law, it has the party, person or company who is using that name or mark has superior rights to that name or mark as soon as it's used in commerce. So as soon as you put that website up with that name on it, you have superior rights to it against all subsequent users. The rights that it gives a user, the common law gives a user, that use in commerce, gives them the right to the equitable remedy of an injunction against a subsequent user. So if you have a name or mark that you haven't registered, but you've been using it in commerce for an extended period of time, or at any time, 2 days, 1 day before the subsequent user, you still have superior rights to it, and you can sue them for an injunction and prevail and enjoin them from continuing to use that mark. Now, the difference is that if you register a mark, you then have statutory protection. Statutory protection gives you not only the right to the injunction, the equitable remedy, but it gives you the right to monetary damages. So you get economic loss, and in many cases, attorney's fees. And the economic damages are measured by the loss of business that the senior user has suffered because of the infringing junior user, or it could be a disgorgement of profits that are gained by that junior user, that infringer, because of its wrongful use of that name. So let's go back to, should you register? So first we've done a search, and we've determined whether that name is infringing on someone else's mark. Now, the standard for infringement is confusingly similar. It's not exactly the same. So if someone is using a name similar to yours, or you're using a name similar to a senior user, it might be spelled slightly different. It might have one other innocuous word in the word mark. It might be, all one word. It could be hyphenated. It could sound like, it could use a symbol that represents a word. There are many criteria by which that confusingly similar is determined. And, in the law, we use the reasonably prudent person standard. So if a reasonably prudent member of the public would be confused as to the source of those goods or services because the names are so similar, then it would be deemed infringement. And there's tons of case law on this. And it also covers trademark rights also cover not just the exact goods and services that a particular product or service are in, but the natural area of expansion. So it covers a class of goods and services, not the exact same one, and the natural area of expansion. So for instance, a beauty salon might also have protection in regard to a hair product line because it's a natural area of expansion for them to go into a hair product line. Or a med spa might have protection for a skincare line because it's a natural area of expansion for them to at some point create a skincare line. So first we want to look at, we want to search for senior users. Now, the first thing I do is I just Google it. But there are, if you're really going to use a mark and you really plan on monetizing it, it's a good idea to do an in-depth search. And whether or not to pay for a search is an analysis that I go through with clients. That this does involve an out-of-pocket cost because we want to look at every single URL. We want to look at every fictitious business name in every county in the country. We want to look at every corporation, LLC, general partnership, LLP that is registered with every Secretary of State of all 50 states. And there's international trademark searching as well, which I don't normally get into because most of my clients are doing business mostly in the US because, a lot of my clients are in the medical field. So whether we do a paid search or not, or we just do our preliminary search is a conversation I have with clients. So now let's say we know that we're not infringing on someone else. So we go, okay, we're clear in that regard. Now we want to look at the economic value of registering. Registering, it does involve some costs. It's not crazy, but first, we want to determine whether we would register in the state or federally with the USPTO. And that depends on whether the client is doing business interstate in more than one state or intra-state, just in the state that they're located in. In most cases, if you're only engaging in intra-state commerce, so for instance, in my case, if a client is only has their customers, clients, patients in California, we would register with the California Secretary of State and not the USPTO. So for example, I gave the example of a hair salon earlier, or a med spa. I represent, hundreds of med spas. The medical services are only going to be provided in California for the most part because the doctors are licensed in California. However, if that practice develops a skincare line, even a medical grade skincare line, that could be sold online and it could be sold throughout the country, even throughout the world. So the brand could potentially be appropriate to register with the USPTO. We want to think about, so that's the discussion of where we would register. Now we're going to think about, should we register? We ask these questions. What is your exit strategy? If you are building a business that you are building to be an acquisition target, in other words, you want to build something and have someone come in and buy you out, and then you go and retire in Belize, it is a really good idea to create a nice, comprehensive IP portfolio. And that's all your patents, trademarks, and copyrights, such as they are, should all be registered because there's more value in that case for a potential buyer. You have a much nicer package of assets to sell. What is the revenue potential for this product or service, and what would be the damage to the goodwill or the reputational value of your product or service, your company, in the event of an infringement? So if you are just creating, something small and you're selling it on Etsy and you're making, you're knitting pot holders or something and making a couple bucks, it might not be worth it to invest in trademark registration. But if you're creating, a larger business that's really creating revenue for you and employees, then the damage to the goodwill, you have a greater revenue potential and your damage to goodwill potential is greater. So registration is more than likely appropriate. But these are the questions we ask when we're determining whether to register. So we talked about common law versus statutory, when to register. So in order to get a mark registered, it must be used in commerce. A lot of clients come to me and say, well, I don't want to put my signage up, or I don't want to publish my website yet until I've registered that trademark because I won't have protection. But again, as soon as you use that name or mark in commerce, you automatically have superior rights to that name or mark. So and you cannot register it until you have it being used in commerce. So we want to get it out there. We want to make it public before we start filing the application. Now there is you can register a mark with an intent to use basis with the USPTO, and then you have to later file a statement of use, but that's kind of complicated and intricate. For the most part, you're going to make sure that mark is being used in commerce and then register it. So what is the registration process like? So there's an application, and the application is not rocket science, but definitely you want to have someone fill it out who has done this before and understands it. There are a lot of questions on there, and you're swearing under oath to the veracity of what you're writing in that application. And you have to provide a sample of the mark, and you have to provide a specimen of the mark, meaning you have to show that it's being used in commerce. For instance, with our hand cream here, we would just send a picture of this label. So that's a specimen, and it shows that it's being used in commerce for this particular product. The specimen has to show the product or service you're using it for. And with our shirt, if our brain is the mark that we're registering, we're going to send a picture of this shirt showing that this is our label in there, and this is a shirt. In fact, for many businesses, our service businesses, we're going to send a web page, and that's there's a detailed way in which you do that as well. So you fill out the application. You have to tell them the first date that you've used it in commerce. You have to send them a sample of the mark and a specimen of its use. Once and you have to pick your class of goods and services. This is also kind of a skill and an art. And this is where sometimes, lay people make mistakes when they're trying to register marks on their own, or they use services like LegalZoom. I don't recommend that unless you really know what you're doing and you've done it before with the help of an attorney, or you are an attorney, because there's a lot of places you can make mistakes. When you pick so for every class of goods and services, there's an additional filing fee, number one. So one of the things I do is try to narrow it to the fewest number of goods and service classes I can. And you want to make sure you pick the correct class of goods and services. And it's complicated and intricate, and it does require some knowledge of the process. So once the application has been sent off, now it's a big hurry up and wait. It will take at least 6 months for a USPTO examining attorney. It's a little faster with the Secretary of State in California. I've never filed one in another state because I'm only licensed in California, but with the USPTO, it takes at least 6 months for an examining attorney to get a hold of your application and take a look at it. Once the examining attorney takes a look at it, they are going to make sure that everything is satisfactory to them. Now, as with all government agencies, the USPTO examining attorneys are human beings, and each human kind of has their own criteria, even though they work supposedly or hopefully under a standardized set of rules. When they're examining these applications, there can be some variance in examining attorneys' responses to or reactions to these applications. If they find something that they feel should be tweaked or changed or missing in the application, they will issue a letter by email to the filing attorney or the individual who filed the application, and it's called an office action. An office action will be final or non-final. A non-final office action is something like, the most problematic non-final office actions are likelihood of confusion, which the examining attorney will say, well, there's another product out there that sells beauty care products and it's spelled ESSY, let's just say. That would be confusingly similar. It's been in existence for the last 10 years, and your mark would be infringing on their mark. So your mark is not registrable based on the fact that there's going to be a likelihood of confusion with that existing mark. The filing attorney's job is then to make legal arguments in support of the fact that this will not infringe on that existing mark. And there's case law on it, and it requires a lot of research. So that's the most problematic type of, and sometimes we prevail and sometimes we don't. But that's why we do a search first, because we don't want to spend the time and money filing that application and then discovering that there's something else out there that we could have easily found if we had paid for that search or done that search. The less problematic office actions are things like, oh, you need to disclaim the word, let's just say, let's see. Let's just take a mark like Gorilla Glue. Let's just say this is called Gorilla Glue. I'm just picking things up off my desk here. If we file a trademark application for a product called Gorilla Glue, if we pass the descriptiveness objection, the USPTO examining attorney might say, you need to disclaim the rights to the word glue in and of itself separate from the mark. And that's an easy fix, and you just answer the office action and agree to that and move on. Sometimes they will have an objection to the way you've described your product or service, and they'll ask for tweaks in that. Sometimes you can do that just with a phone call, but for the most part, a response to office action must be actually filed. You have 6 months to file a response to the office action. This sounds like a long time, but it is not necessarily a long time. Time flies really fast with these things, and especially if research is required. Once the office actions have all been satisfied, presuming that we are still on the road to publication or to registration, the mark will be published in the USPTO Gazette. The USPTO Gazette, this is akin to publishing, like, for instance, a fictitious business name, which we publish in, a local newspaper to put the public on notice that I'm going to claim rights to this name and I'm going to register this name. That's a whole nother issue in and of itself. I don't want to go down that road, but the USPTO Gazette is an online publication that says to the world, okay, we're going to register this name. You have 30 days to object. Speak now or forever hold your peace. And if that 30 days goes by and there's no objection to the registration of that mark will be registered, and you will get a beautiful envelope in the mail like this, and a certificate which is beautiful and appropriate for framing like this. Now, that's not the end of it. Once you're registered, there is all kinds of maintenance that you have to adhere to, and it's described on the back of the certificate. And there are filing requirements that you must meet. You must first file a declaration of use between the 5th and 6th years after registration. And then you must also file a declaration of use between the 9th and 10th years of application. You must file a declaration of use in an application for renewal every 9th and 10th year period calculated from the registration date. So there is maintenance. It's described in detail on the back of the certificate. And the USPTO does send out emails to remind us of these things. They are not required to remind us. It is our job to remember to renew these filings, but that's the maintenance process. So let's talk about some ancillary issues to trademark use. There are some other protected categories of intellectual property that are not registered that are akin to trademark, and one of them is trade dress. And I use this Coca-Cola can as an example. So if I created some kind of drink and I put it in any red can with any white swirl line on it that may or may not, it could be even a horizontal swirl line, that would more than likely be deemed infringing on Coca-Cola Company's trade dress. It is the look and feel of a product. There can be a sound mark, there can be scent that can be infringed on. So we don't want to capitalize on someone else's marketing that they have engaged in for many, many years and expended all kinds of resources to develop goodwill behind a particular mark by infringing on their trade dress. I've never had a case about trade dress, but it is a thing. Use of name and likeness. I did have a case about use of name and likeness. So a famous person who has generated revenue around their name and likeness, it is unlawful to infringe on their use of name, to use their name and likeness for your own gain. I had a client who had a product, a consumable product, and he had this idea of branding it using some dead celebrities' names. Just because a celebrity is dead doesn't mean that there's not a legacy out there who has ownership of that name and likeness. For instance, our friend Elvis Presley here. My client received a cease and desist letter and a demand for a disgorgement of profits. It was a very long, drawn out, costly negotiation, and he did pay a settlement amount that was in the over $10,000 by at least 5 times. And so don't use, even a D-list or dead celebrity's name and likeness. Another basis for litigation is the Unfair Business Practices Act in California. There is probably a similar act in every state. These are other bases on which you can or someone else can acquire remedies against you for unfair business practices. So for instance, if you don't have a trademark registered, or even if you do have a trademark registered, and someone infringes on it, you can sue under the Lanham Act, which is the USPTO or the Federal Trademark Act. You can sue under state trademark law, and you can sue under the Unfair Business Practices Act that says, essentially, if you do something unlawful and it damages my business in any way, I can sue you and get monetary damages for it. And as I said before, the measure of damages is either, for the most part, it's either the amount of, it's a disgorgement of profits, the amount of money that that junior user wrongfully made by the use of by the unlawful or unfair use of your intellectual property, or the amount of revenue that you, the senior user, lost because of their unlawful use. My very first jury trial, and I don't really litigate anymore, but I used to, I refer to it as the Sicilian pizza case. Like Perry Mason, I name all my cases. And in this case, a client had bought a business from a restaurant from another restaurant owner, and there was a 5-year, 5-mile non-compete clause in there. And just under the 5 years, the seller opened another business exactly like the one they sold my client, using the same name, the same menu, and everything. So not only did they infringe on the trademark, the common law mark, it wasn't registered, they engaged in unfair business practices. We could only prove one pizza had been purchased by a customer who had intended to go to my client's restaurant, but went to this other restaurant. And it was like something like, back in those days, $4.95. We got the $4.95 damages, but we got $60,000 in punitive damages. So it was well worth it, and it is provable, but it takes a lot of work, and litigation is always costly. So infringement issues. So what do you do if you discover infringement? Well, don't do anything on your own. I don't recommend that in legal issues. Get an attorney, get that cease and desist letter out, and get the negotiation going. Most of the time when a cease and desist letter goes out, the recipient of that letter will comply, and it'll be bing, bang, boom, nothing paid, nothing wrong. For the most part, parties against whom one is infringing just want the infringer to stop. I had a client who used the name for her business. She used an iconic brand, internationally known brand. If I said the brand, you would immediately associate it with that product. And no one told her not to, including her prior attorney. And she then said, well, I'm going to register the trademark for this mark. So she registered it with the USPTO, which was also inappropriate because she was only doing business in California, and did it herself. And the thing is that these big companies with big IP portfolios have search services out there. They get alerts when anyone is filing a trademark that might infringe on theirs, and they take a look at it. Well, that's what happened in this case. And my client got a 4-page cease and desist letter from an LA law firm and, came to me. The plaintiff, or the party against whom my client was infringing, wanted her to disgorge profits, give an accounting of profits, and also turn over all her social media to them. Well, I got involved, started working with the other attorney. We just said, listen, we're going to stop using it. We didn't know. My client had, she was just a one-off mom and pop shop, had been using it for 2 years though, which is why it's always good to do that search and talk to an attorney early, because we did not turn her social media over, but we scrubbed it and took out every indice that related to that brand, even the color scheme that was associated with that brand. And we stopped using it. And we provided proof of this to the party who was demanding all these things, and they were fine with that and went away. So that's what you do if you receive a cease and desist letter, is you contact your attorney. The way these laws are enforced in the civil realm is through the courtroom, is through litigation. And as my civil procedure said to me in law school all those years ago, nothing good ever happens in a courtroom. And that is true. It is very expensive. And even if you win, you have spent a lot of money to get there. It has taken months, maybe years. It's a lot of mental and emotional energy that you put out in dealing with it. It's very, very stressful. And so negotiation and settlement is always better, because litigation, not only is it costly, time consuming, and stressful, but you never know what the outcome is going to be. It's like throwing dice. It's like going to Vegas. You never know what a jury is going to come up with, regardless of how strong you think your case is. So a sure thing, a bird in the hand is worth 2 in the bush. The sure thing is always better. The legal system is not about justice. Anyone who's ever been involved in the legal system knows that it's about trying to enforce the law to the best of our ability, but it's not necessarily about fairness or justice. And particularly in the intellectual property realm, the deep pocket wins, because it's that party who can expend the most amount of funds into the litigation and put pressure on the other party who's going to win. These suits are very costly. That's why it's a really good idea to get a good negotiator on your side early on and negotiate it out. So that is the Trademark 101 that I promised you all. This has been recorded. It will go up on my YouTube channel. If anyone has any questions, you can email me. You can put it in the chat box. You can put it in the chat under the YouTube video. And I want to thank everybody for coming, and that this will go up on my YouTube channel.